Question number 2 relating to contract of guarantee is define and illustrate the contract of guarantee and as it is provided under section 126 as contract of guarantee, so also the illustration relating to this section. So, as provided under section 126 of the Act, a contract of guarantee is a contract to perform the promises or discharge the liability of a third person in case of his default. So, anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. And the very illustration regarding the contract of guarantee as, for example, B request A to sell and deliver to him goods on credit. A agrees to do so provided she will guarantee the payment of the price of the goods. She promises to guarantee the payment in consideration of A's promise to deliver the goods. This is a sufficient consideration for C's promise, and in that connection, we will discuss a very important leading case, and that is Loyalka versus Sarupji Bhovangri. In 1940, the Bombay High Court observed since the contract of guarantee involves three parties, the creditor, the surety, and the principal debtor, there must be a contract, first of all, between the principal debtor and the creditor that lays the foundation for the whole transaction. And as decided in another leading case, that is State Bank of Patiala versus Sri Durga Oil and Flour Mills and others in 1984 by the Himachal Pradesh High Court, as where a loan was advanced by the plaintiff bank to the defendant. A principal debtor and the guarantors had written a letter to the bank mentioning that they have created an equitable mortgage in favor of the plaintiff by deposit of title deeds of their property for the loan advanced to defendant. The principal debtor, the letter of for loan advanced to the defendant. So the very letter was sufficient to prove that they were guarantors for the repayment of the loan and created an equitable mortgage by depositing the title deeds. And now we'll discuss regarding bank guarantee. So, in connection to bank guarantee, we'll discuss certain leading cases such as MS Basant Realmers Alwar versus State Chemical and Pharmaceuticals Corporation of India Limited in 1986 by the Rajasthan High Court. So, according to the very observation of the Rajasthan High Court, bank guarantee for all purposes should be taken to be a credit note issued by the bank in favor of the person in whose favor the bank guarantee has been issued, and it should be encashable just like a credit note ordinarily, unless the intention of the parties is otherwise. For example, there may be a case in which the parties come to an understanding that the liquidated damages will be determined, and after the determination of the liquidated damages, the bank guarantee should be encashed. In such matter, the court should not and generally cannot interfere in the matter of encashment of the bank guarantee. So, in another important leading case leading to bank guarantee is DTS Construction Private Limited versus Steel Authority of India Limited, and another in 1986. The Calcutta High Court observed that if the notice of demand by the beneficiary of a bank guarantee is not strictly in accordance with the language of the bank guarantee, that would not be an excuse for the bank for non-payment of the amount due under the guarantee. If the bank has understood the purpose of the notice, then the bank cannot be had to say that there has been no statement in the notice that the beneficiary has suffered loss and or damages on account of the defaults committed by the person on whose behalf the guarantee was given. Even if the notice is bad, that will not help the bank ultimately, because the beneficiary can give a fresh notice strictly in compliance with the language and words of the guarantee to the bank. If there is substantial compliance with the terms of the guarantee in the notice, that would be sufficient. And if there be no defect in understanding the nature and purpose of such notice by the bank is bound to honor its commitment under the guarantee as it was held by the Calcutta High Court in the leading case DTS Construction Private Limited versus Steel Authority of India Limited, and another in 1986. So also in another important leading case, that is MS Arugal Murmugaon Traders versus Rashtriya Chemicals and Fertilizers Limited, Bombay, and another in 1986. The Madras High Court observed there is no absolute rule prohibiting grant of interim injunction to bank guarantees, and in exceptional cases, courts will interfere with the machinery of irrevocable obligations assumed by banks, and that the plaintiff must establish a prima facie case, meaning thereby that there is a bona fide contention between the parties or serious questions to be tried, and further the balance of convenience is also a relevant factor. If the element of fraud exists, then the courts step in to prevent one of the parties to the contract from deriving unjust enrichment by invoking bank guarantee, as it was decided in MS Arul Murugan Traders versus Rashtriya Chemicals and Fertilizer Limited's Bombay and another in 1986 by the Madras High Court. Also, in another important leading case, and that is Syntax India Limited versus Birmer Impex Inc. and others in 1986, the Supreme Court held that commitments of banks must be allowed to be honored free from interference by the courts. Otherwise, trust in international commerce would be irreparably damaged. So, these are the important leading cases relating to bank guarantee, also relating to contract of guarantee. And in our question number 3, that is relating to what is consideration of guarantee. So, which is provided under section 127 with illustration. So, the very consideration of guarantee as provided under section 127, as we have already seen that a contract without consideration is void, so is the case with a contract of guarantee. But here the consideration may be anything done or any promise made for the benefit of the principal debtor. So, anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. And regarding the very illustration, as for example, B requests A to sell and deliver to him goods on credit. A agrees to do so, provided C will guarantee the payment of the price of the goods. C promises to guarantee the payment in consideration of A's promise to deliver the goods. This is sufficient consideration for C's promise, and so also in another illustration, as A sells and delivers goods to B, C afterwards requests A to forbear to sue B for the debt for a year and promises that if he does so, she will pay for them in default of payment of B. A agrees to forbear as requested, and this is sufficient consideration for C's promise. And so also we'll discuss another illustration. A sells and delivers goods to B. She afterwards, without consideration, agrees to pay for them in default of B. The agreement is void. So, the consideration for suretyship must exist in some form before a contract of guarantee can be valid. So, the money lent to the principal debtor on the faith of the guarantee is a sufficient consideration for the promise of the surety. It is not necessary that there should be some benefit to the surety himself, and regarding to refraining from launching the prosecution is a sufficient consideration for the promise made by a surety. It has been held that the contract of surety may be invalidated when the consideration was withdrawal of criminal prosecution against the debtor, but the court would not sanction the withdrawal if the offense was not compoundable. So, in relating to consideration of guarantee, we will discuss the leading case State Bank of Patiala versus Sri Durga Oil and Flour Mills and others in 1984 as decided by the Himachal Pradesh High Court, where the principal debtor acknowledged his liability by executing revival later when the guarantor was existing as guarantor. It was held that the acknowledgement was binding on the surety or guarantor, and he was liable for repayment of loan. So also, in another important question, and that is question number 4: what is continuing guarantee? How is it revoked? And as it is provided under section 129 of the Indian Contract Act, and the very illustration and the very important leading cases relating to continuing guarantee and its revocation, we would like to discuss the very important leading case, that is the Eastern Bank Limited versus Paras Services of India Limited and other in 1986 decision of Calcutta High Court. Then Bhavani Shankar Patra versus State Bank of India 1986 by the Odisha High Court in our upcoming video.